Kamlesh, you can start. We are now live on YouTube. You are on mute, Kamlesh.
Good afternoon, dear viewers. My name is Kamlesh Singh, and I am the media cell head of Just Corpus and today's host of today's session. I, on behalf of the whole team of Just Corpus, welcome you all in the today's session on the new criminal law regime and its impact on the personal liberty. But before we dive deep into the today's discussion, let me provide with you a brief introduction of the Just Corpus and the eminent guest of today's session, Advocate Harshit Anand sir. Let's first start with introducing the eminent body Just Corpus. Just Corpus is a body of legal professionals who have come together to bring various aspects and chain of law under a single umbrella. Just Corpus is an edtech platform set up in 2020 and has a wide reach of 600 clicks per month on an average basis on our website www.justcorpus.com. The inspiration was derived from the ever-growing need for the law student. Just Corpus has incorporated an interdisciplinary journal and a multidisciplinary journal as its subsidiaries named as the Just Corpus Law Journal and the International Journal of Law, Research, Education and Social Sciences. Now, turning our attention to the focal point of today's event, today's YouTube Live, we are privileged and we are honored to have Advocate Harshit Anand sir as an esteemed guest speaker of this today's session. Um, well, Advocate Harshit Anand sir is a practicing advocate at Supreme Court of India. Sir has previously worked at Khaitan Company, Kolkata, at the Trilegal Gurgaon in the year 2022-2023. He has represented Raghav Chadha in the matter of suspension before the Supreme Court of India and CPIM in the electoral bond matter before the Supreme Court of India. Sir is an alumnus of Chanakya National Law University, Patna. Sir represented and advised the Usha Martin Group on the acquisition of its steel business by the Tata Group, widely reported as Deal of the Year 2019. Sir has been an actively mooter. During his time in the law school, some of his achievements in the moot court competition are that he was the winner and the best speaker at the Yasaswy Memorial National Moot Court competition on Constitutional Law 2018. He was also the winner in the 5th RGNUL National Moot Court competition in the year 2016. Sir also has actively participated and took a keen interest when it came to legal research and writing. He was the student editor of the CNLU Law Journal, Volume 5 to Volume 7 till 2018. He has contributed Courts of India, Past to Present, a book published under the aegis of the Supreme Court of India by the Publication Division, Government of India in 2016. Without further ado, I would like to hand over the floor to Sir for his insight on today's topic. Thank you, sir. Sir, over to you now.
Thank you, Kamlesh, and a very good afternoon to Just Corpus, the organizers, and everybody who's tuned in today. I hope I'm audible, and I would not waste much time, and I'll just simply move to the topic at hand, which is the new criminal laws, which has been one of the most talked about, discussed, written about topics of recent times in law, at least. And there's a lot of material available online already, which gives you a detailed analysis of what has changed insofar as criminal code or the criminal law which governs India. What are the changes? To what extent the changes have happened? What are the substantive changes? What are the cosmetic changes? I'm pretty sure there's a lot of material available online already, and there's nothing that I can tell you which you can't find at the click of two buttons on Google. But this discussion, this small session, this short session of say 30-40 minutes is aimed at a very specific aspect, which is to discuss the impact of these new laws insofar as the aspect of personal liberty is concerned, and what is the overall impact of these changes. Uh, is it for the good? Is it for the worse? So this is what we want to, this is the aspect on which I want to focus insofar as this session is concerned. What I'll do is I'll give you a brief overview of the repackaging which has happened. What is the official version, or what is the packaging which which is what is the manner in which these new laws have been presented to you? What has the government said about it? What is the actual meaning of it? And through a few provisions, not many, I would say not more than 2 to 3 provisions, I would try and explain to you as to whether or how the laws have actually become a tool to throttle personal liberty rather than, say, uphold personal liberty. So there's one term which has been thrown around a lot insofar as uh, these 3 laws are concerned. Whenever we discuss these laws, or whenever we hear discussions by eminent lawyers or senior counsels of the Supreme Court, or when we read articles in newspapers or leading magazines, there's one term which gets thrown around a lot, which is decolonization. And when we talk about decolonization with respect to laws, there's a certain meaning that needs to be ascribed to the phrase or the term decolonization. What does decolonization mean, simply speaking? Simply speaking, decolonization would mean that the colonial pall or the colonial cloud hanging over our laws, which are no doubt antiquated, old. Most of these laws are the laws made by the British, given by the British to the colony, which was India. So decolonization in its simplest sense would mean that we would disconnect from our colonial past and make our own laws, which usher us into an era of more democratic governance, more pro-people governance, a governance which has the people at its center. The difference is that in the colonial era, when laws were drafted or when laws were promulgated, passed, the interest of the state was always above the interest of the individual. And the reason is, as all of you would already know, is that the model of governance that any colony, that any oppressor, that any imperial government, such as the old British government, that the British Raj, would follow is the control model, where citizens are not equal, where the state is the governing authority, state is the controlling authority, and the people of the colony have to be controlled so as to get a model favorable behavior so that maximum profit output can be extracted out of the colony. So one can reasonably assume that when these laws were enacted, that is the Indian Penal Code, the Code of Civil Procedure, the old one, I'm not talking about the 1973 one, the old one, and the Indian Evidence Act, when these laws came for the first time, what would have been at the back of their minds, the back of the minds of framers, was not the interest of the people, was not to uphold personal liberty or equality or fair trial, so to speak. The primary objective, the main objective would have been to create a model which allows maximum leeway to the British government and their officials exercising power through these courts, to give them maximum leeway to act in a function where they can control the people, where people can be disciplined, so to speak, and any kind of divergence, any kind of act against the state which can threaten the government, which can threaten the imperial government, its presence in India, those acts need to be curtailed. Those acts needed to be put down with a strong hand. So one can reasonably assume that when these laws were enacted for the first time, this was the mindset, or this was the underlying, I would say, reason informing all of these laws, the old criminal laws. Now, when the government of India, the present government of India, brought these laws for the first time, the idea was to decolonize criminal law. So when we talk about decolonization in the present context, the most primary component of such decolonization should be to disconnect from this imperial past, to disconnect from this control model. Because all of us know that once India became independent and once the constitution was enacted in the year 1950, India ushered, governance-wise, India ushered into a different era. Citizens were no longer subjects. We are not subjects of the Indian government. Citizens, we live in a welfare state where citizens are treated as equals, where human rights, rights of citizens, where right to life has been given a very, very broad meaning. It includes elements of fair trial. It includes elements of dignity. It includes element of a speedy trial. Then you have articles which protect you from self-incrimination. You have articles which protect you from double jeopardy. You have articles which guarantee equal treatment, even if you are up against the most powerful person in the country. Now, these articles have certain meaning, and these articles are not just articles in isolation. These articles also inform each and every law which governs citizens in this country or individuals. So, as soon as the Constitution of India was enacted, the very nature of the criminal laws or the logic which informed criminal laws in India, even that changed. So if we had a provision of sedition in British India, which allowed the government, the British government, to imprison any person who spoke against the colonial government, the meaning of that provision changed. Now, criticism of the government of India by any ordinary citizen cannot be a ground to invoke sedition, cannot be a ground to say that that person is waging or is trying to wage a war against the state. Because in a democratic country, in a welfare state, everybody has a right to engage in, indulge in constructive criticism, in healthy criticism of the government. So what I'm trying to say is that with the promulgation, with the enactment of the Constitution, the logic underlying criminal law changed. So similarly, when these new laws were enacted, the logic of the Constitution should have informed each of these laws. And to an extent, they have. For example, we have seen that the provision such as sedition, so the provision of sedition has been put into abeyance. But what have those provisions been replaced with? And what are the other provisions? What are the regular procedural provisions which make us believe, or which in the current law are problematic, or are, I would go to the extent of saying that, are not in consonance with the constitutional values of personal liberty? Because once again, coming back to the central idea, which is decolonization, the central idea of decolonization is to bring the citizen at par with the state, where the state is no longer the authority which exercises control. It is an authority which regulates citizens. It is an authority which has to see a citizen as an equal. It has to work constantly for the welfare of the citizen. And in all matters where bail is warranted, where liberty has to be given precedence, their liberty should be given precedence. That is the meaning of a welfare state. That is the meaning enshrined under the various provisions of our Constitution. That is the meaning that the Supreme Court and the courts of India from time to time have given to articles such as Article 14 and 19 and 21. and other articles. Now, what we need to examine by examination of certain provisions. And of course, this, once again, give you a warning, a fair warning and a fair disclaimer that this discussion does not aim to be a very, very exhaustive discussion on the topic, because it's simply not possible. And like I said, there is nothing that I can tell you which you cannot find and read for yourself or see for yourself on the internet. But my goal here is to simply put certain provisions in perspective and make you think whether the situation has improved for the better or for the worse. So let us take an example of a provision. Now, you all know what the changes have happened. From July 1, the three laws have been replaced. The Indian Penal Code of 1860 is now the Bharatiya Nyaya Sanhita, which is the BNS. The Code of Criminal Procedure of 1973 is now the Bharatiya Nagrik Suraksha Sanhita, which is the BNSS. And the Indian Evidence Act of 1872 is now the Bharatiya Sakshya Adhiniyam, which is the BSB. So these are the three broad changes which have happened. These are the three replacements of codes which have happened. Now, one thing that we know, or one thing that has been talked about at length and which has been emphasized upon by the government, by civil society, by lawyers, is that the provision of sedition is no longer a part of our criminal law. Sedition has been done away with. But I would like to draw your attention to another provision in the Bharatiya Nyaya Sanhita, or the old Indian Penal Code, which replaces, I would say that replaces sedition. But you also have to see the language that it employs. The provision is section 152 of the BNS. And if you have the law or the act, the code available, you can open it also. So section 152 of the Bharatiya Nyaya Sanhita criminalizes acts endangering sovereignty, unity, and integrity of India. And if you read the law, if you read the bare text of the provision, you would find that it is even wider than the erstwhile sedition provision. So if you read the law, the bare text, it says, whoever purposely or knowingly by words, spoken or written, or by visible representation, signs, electronic communication, financial mean, or otherwise, excites or attempts to excite. Now, then there are certain things which are a part of our law already, which are there in different laws, or which were part of the erstwhile IPC, like I said. For example, secession, armed rebellion, subversive activities, or encouragement of feelings of separatist activities. These are activities that have always remained criminalized in India. But then it goes on to say, or endangers sovereignty or unity and integrity of India, or indulges or commits any such act, shall be punished with life imprisonment. So the maximum punishment that has been prescribed under this section is life imprisonment. It may extend till 7 years. So you can say that that maximum punishment that can be given under this provision is for 7 years, but 7 years is a long time. But what is problematic here, or what you need to focus on, what you need to pay attention on as a lawyer, or even as a concerned citizen, is the broad terminology that has been employed in the law. So when you say endangering sovereignty or unity and integrity of India, what exactly do you mean? Or what meaning can the political class which is ruling India, or which is at the power, at the helm at that given point of time, what meaning does it ascribe to sovereignty, unity, and integrity? That meaning is important. One thing that we are taught as lawyers, and one thing which we see as practitioners day in and day out, is that the most important component of law and law practice or law interpretation is predictability in law. Is that law should be predictable. The scope of arbitrary action, the scope of discretion should be minimized to the extent possible. That is to say that these laws, these criminal laws, will be implemented by whom? These criminal laws will be implemented by state agencies. This criminal law will be implemented by state government police, by central government. Now, the idea is that when you use terminologies such as these, you vest wide powers in the hands of the executive, in the hands of these agencies, to give it the meaning that they want to give it to. And to place such wide powers in the hands of an enforcement agencies, which may have many interests in its mind. But the most important interest for a political class, for the political class which is ruling you or which is at the helm of the powers, is maintenance of its power, is continuation of power, is to thwart and regulate or put an end to any kind of challenge to its power. And these are not things that I'm telling you, or these are not things that I'm telling you out of my own fine wisdom, or these are not things I'm pulling out of thin air. All of you are adults, all of you may be students of law, or students of different disciplines, or just general, just concerned citizens. You know, this is exactly how governance happens. You know that at the back of the mind of each government, preservation of power is one of the primary objectives. Now, if a government starts going after dissidents, which we have seen happening in the recent past, which we have seen happening under every government, if the government starts going after its dissidents, if the government starts going after voices which oppose it in public or in places of eminence or in places which matter, using provisions such as these, giving a spin to phrases such as unity and integrity and sovereignty, because those people are critical of the government and the government policies and the government actions, which may be of any kind, which may be a policy decision, which may be a decision taken vis-a-vis a neighboring state, which may be decisions taken vis-a-vis a foreign policy, which may be decisions taken vis-a-vis a financial move, a move related to internal security. Now, if the government tries and gives a spin to such speeches, let alone actions, because the provision says by words, spoken or written, or by signs, by representation, electronic communication, financial mean. If the government starts weaponizing these open-ended, wide words to suppress dissent, to suppress opposition voices, and starts putting them in jail, then I want you to ask yourself, what happens to the cause of personal liberty and what happens to the cause of democracy? So this is what we have to be mindful about. When we talk about decolonization, let me come back to the original point of discussion. The original point of discussion was decolonization. The purpose of the law was decolonization. Now I ask you a question. If decolonization is the purpose and you already have specialized laws which have provisions to prosecute people for acts against the state, for acts of terrorism, for acts endangering public safety, why use or why put such open-ended provisions in the law when you already have the UAPA, when you already have the Public Safety Act? So these are questions that we need to ask ourselves. These are questions that we need to engage with when we speak of decolonization, especially in context of the new criminal laws. Now, this is one provision. This is section 152. Now, I want to bring your attention to another aspect, which is another provision of the substantive law, which is the Bharatiya Nyaya Sanhita, which is section 113. And again, if you have the law available with you, if you have it open, then you can probably go to that provision, which is provision 113. Now, provision 113 is quite interesting because provision 113 deals with terrorist acts. And like I was telling you, India already has a specialized legislation to deal with terrorist acts. So what does this provision do exactly? What exactly is the purpose? And what are the terminologies which it employs? It employs terminologies such as activities which are done with the intent to threaten or even likely to threaten the unity. Again, same set of words which do not have any steadfast, any concrete meaning, which can be given a spin to, which can mean anything in a particular context per the government enforcement agencies. Unity, integrity, sovereignty, security, economic security. Now, one can understand that the government has an interest in protecting its people, and it's completely justified. It's completely justified to enact laws or have laws or systems in place which can account for these activities, because of course the government has an interest in protecting its citizens. The government has an interest in prosecuting terrorists. But the question one needs to ask is, why this multiplicity? What is the need of having these multiple sets of laws at different levels for activities which can broadly be categorized in one and the same category, which can be fit in one and the same category? Now, what this provision means, that now terrorist activities can be prosecuted or can be taken hold of or can be proceeded against with by the state government also. So what you can assume now is that for the same offense, now the central government will move against you or move against the concerned person under the central law, under which the central government has powers. Let's say the UAPA, the Unlawful Activities Prevention Act. And for the same offense, the state government will move against you under this provision. Now, a lot of practical difficulties may arise out of it. Who has jurisdiction? Which law will prevail? Who will have custody? For what purpose? Now, these are challenges which have grave implications for personal liberty. Because earlier, say if an activist if an activist or a professor, like we have seen these things happening, say if an activist or a professor is arrested under a terrorism legislation, a legislation aimed at curbing terrorism. Now, other than the central agency, you have the state government also going after you. So what does it mean for personal liberty? Does it make obtainment of bail easier? Does it make it harder? Does it make it more cumbersome? Does it make it more complicated? These are questions that we are yet to encounter, because we are yet to see these laws in action. But from the look of it and from what it appears, one can assume that certain practical difficulties are coming our way. I'm not even on the aspect of the misuse of law, the aspect of abuse of law by enforcement agencies or by errant police officers, which is not unheard of in India. Abuse of law by errant officers officers who do not willingly or unwittingly follow the dictate of the law as interpreted by courts, as limited by courts from time to time. Now, what does it do? What would it do for those aspects of misuse is something that we have already discussed. But simply from the point of view of convenience in governance, convenience in implementation of law, even from that aspect, jurisdictional problems will arise. Now, third aspect, another aspect that I would like to draw your attention to, and this again is now an aspect of, I would say, procedure. An aspect of procedure. This is not an aspect. Right now, the two sections that we discussed were aspects of substantive law and the meaning that can be given to substantive law by governments. But the third aspect, and perhaps the more concerning aspect, is the aspect of procedure. And all of us know, like all of us who have basic education in criminal law also, like even if we have basic education in criminal law, we know that matters of criminal law are governed more by procedure than by substantive law. Procedure becomes as important, if not more important than substantive law for everything, for your bail, for your trial, for your conviction, for your release, everything. Now, if you look at one particular section in the Bharatiya Nagrik Suraksha Sanhita, which is a new version of your CRPC, which is the BNSS, you will see a particular provision. And again, I'm limiting myself to discussions on very, very limited basic provisions because I do not want to confuse you and I don't want to unnecessarily widen the ambit of this discussion. We only have to look at certain very basic things, and the rest of the reading you can always do on your own. If you look at section 187, the new section 187 of the Bharatiya Nagrik Suraksha Sanhita. So this section deals with the procedure of investigation that has to be adopted when any investigation cannot be completed in 24 hours. So if you read 187 subsection 1, you will simply see that when a person is arrested and detained in custody and it appears to the investigating officer that investigation cannot be completed within the period of 24 hours, and of course he has grounds to believe that accusation is well-founded, it has some basis. So the officer in charge of the police station or whoever is making the investigation, of course, has to be at the rank of sub-inspector. So they shall transmit to the nearest magistrate a copy of the entries relating to the case and shall at the same time forward the accused to the magistrate. Now, this is a constitutional requirement. This presentment of 24 hours is a constitutional requirement that has to be followed. And that is in the law, 187(1). Now, the second part says, the magistrate before whom such accused person has been forwarded under this section, irrespective of whether they have the jurisdiction or not to try the case, and after taking into consideration whether this person has been released on bail or whether his bail has been cancelled from time to time, authorized from time to time, the magistrate, as he deems fit or as she deems fit, they may extend the detention for a term not exceeding 15 days in the whole at any time during the initial 40 days or 60 days out of the detention period of 60 days or 90 days, as provided in subsection 3, as if he has no jurisdiction to try the case or commit it for trial and considers further detention unnecessary, he may order the accused to be forwarded to a magistrate having such jurisdiction. Now, the third part becomes interesting. The third part will clarify what the second part wants to say, because the second part is quite confusing. You'd say that you think that what exactly is a magistrate, what exactly can the magistrate do, or what exactly can they not do. Now, if you come to the third part is quite clear. It unequivocally lays down that the magistrate may authorize the detention of the accused person beyond the period of 15 days if he is satisfied that adequate grounds exist for doing so. But what is the time period for such extension can happen? 90 days, where the investigation relates to an offense, say, punishable with death, life, 7 years, sorry, 10, death, life, and 10 years. And 60 days, where the investigation relates to any other offense. So for any other offense, it can be 60 days. For death, life imprisonment, and 10 years, it can be 90 days. Now, what are the implications of this? And to understand the implications of this, you have to understand the difference between the police custody and a judicial custody. The reason why courts our Supreme Court and different high courts from time to time, and our jurisprudence and our liberty jurisprudence in general, employs a very, very high standard of review, at least in theory, in cases of police remand. And why is that? The reason is to protect an accused against police excesses. Because one can assume that if a person is in police custody, the person is under immense pressure and is open to excesses by way of physical torture, by way of mental torture by the police, because the police has an interest in proving its case. The police has an interest in getting a confession, although that may not be inadmissible. That may not be admissible. So that is why the aspect of police remand or a police custody comes with a lot of inherent limitations which have been put in first by the Constitution and second by judicial exposition from time to time. Now, this provision, 187, completely dilutes years and years of liberty jurisprudence. Because now, even police custody can be extended for 60 days and 90 days, which is completely unheard of as far as Indian jurisprudence is concerned, which is the constitutional position of which is completely untenable. Now, I again bring you back to the central question. What does it do for personal liberty? And what does it do for the cause of decolonization? The purpose of decolonization, the purpose of making our criminal laws more pro-liberty was to protect people from police excesses, was to protect people from police abuse of provisions by vesting wide discretionary powers in the hands of the investigative and the implementing authorities, which is the police and the investigative agencies. Now, if you have retained and put in provisions such as these, how exactly are we going to ensure that these provisions will not be abused by the enforcement agency, which has, like I told you, which has an interest in proving its own case, which has an interest in putting people behind bars, which pose any kind of threat to its power? And I'm not talking about one government or the other government. This is the nature of the political class. This is the nature of how governments operate across the world, across continents, across history. So how exactly is this law? How exactly are these laws, apart from its ostensible commitment to, say, time-bound disposal, apart from its good components, such as community engagement provisions, how exactly do we reconcile these provisions, these 2 or 3 provisions that I pointed out to you, with the larger cause of upholding personal liberty? That is my question to you today. So I think this is the groundwork that I wanted to lay for you. I don't want to give information after information and fill your mind with a lot of provisions and case laws, because those are things that you anyway read and you will find in plenty. But what I wanted to make you do today is think about the genesis of these provisions, the meaning of the term decolonization. What exactly does it entail? Are we achieving decolonization through these provisions? And when these provisions actually play out in real life, which they will, now that the law is in operation, what will we see? Will we actually see decolonization? Will we actually see police powers curtailed vis-a-vis citizen powers or citizen rights? Or will we see even more abuse? Will we see even more complications? So these are questions that we have to think about. Of course, there are no definite yes or no answers, but of course, these are questions. These are complicated questions which merit an answer. Maybe those answers will come from experience. Maybe those answers will come from landmark case laws. I do not know today. You do not know today. But these are aspects of these new criminal laws that we have to constantly think about, that we have to constantly write about, or that we have to constantly find of ways to improve upon through our own experience as lawyers or students of law, or just concerned citizens interested in causes of liberty, interested in causes of championing human rights or individual rights. So that's it. That's about it. If you have any questions regarding this, please do not ask me questions about provisions of law and what are the changes, what are the section-wise changes or removal. Those are questions that, see, I don't want to answer for you. Those are study materials. Those are not discussion points. I want you to ask your questions from discussion point perspectives. What is your opinion of the law? If you disagree with me, if you agree with me, what exactly do you have to say? So please start with your questions. We have 10 more minutes. We can wrap it up after that. Thank you.
Thank you, sir, for sharing your valuable insights. Now I invite all the participants to engage in the question and answer round, where you are free to ask question to Harshit, sir. So we have few pending questions which we have received before. I'll be asking them one by one. I'll be putting forward change in criminal laws has affected the today's legal system.
Sorry, can you come again? I didn't get the question.
Yes, sir. Sir, how the change in the criminal laws has affected the today's legal system?
See, this is a very broad question. How the criminal laws have affected the legal system is a question that can't be answered in say 2 minutes. But I would say, see, apart from like what I even mentioned while I was speaking, that see, apart from these larger questions of personal liberty or the impact on citizenry, large question of convenience and reconciliation between the old laws and new laws has also arisen. Now, see, it's easy for, say, an outsider or a non-informed person to say that now everything is time bound and so there will be disposal of cases in a swift manner. But anybody who has had an opportunity to deal with the criminal justice system in India, or just to see and observe how things happen in our trial courts, in even in our higher judiciary, the amount of time it takes, the way investigations are conducted, the time it takes for witness depositions, for examination, cross-examination. It's very, very difficult to reconcile these new provisions with a system that has existed for hundreds of years. Now that you have a new system and then you have such pendency of cases in the old system, of course, there are ways to reconcile it. Of course, there's a cutoff date after which the new law will be followed. In certain cases, the old law will be followed for substantive law and the new law will be followed for procedural law. So see, these are creases which have to be ironed out. And this ironing out will take time. So it will take a lot of time and see, we think of things from a very macro level. We sit in Delhi or say in metro cities or in one particular city and we think only from the perspective of one city. But if you see, criminal law implementation in most places happens in the local language. Now, a lot of time will be taken for capacity building programs. It will take a lot of time. It will take a lot of effort from the governments. It will take sessions after sessions, seminars after seminars to train the police officers, to train the havildars, the constables, the forensic authorities, the lower judiciary judges, the munsifs, the DJs, the metropolitan magistrates. You have to understand the magnanimity, the scale of things that need to happen. A lot of for every language in India, there needs to be a translation of all these laws. Because like I told you, governance, the criminal governance, criminal enforcement happens in the local language. So the local police thana, the SHO, needs to have a copy in Kannada, or needs to have a copy in Marathi, or needs to have a copy in Telugu, needs to have a copy in Hindi. I'm pretty sure there must be a Hindi translation by now. So all of these things take time, and all of these things, like I said, take capacity building initiatives. So we'll see a lot of these things happening in the next couple of years. We'll see, and I'm pretty sure as I speak, it is happening, because there's no other way to do criminal enforcement. It's a massive change. It's a sea change. It might just appear for us as practitioners of law sitting in one place, it might just appear replacement of one piece of document by the other. But the kind of practical changes it has ushered is huge. It's the scale of it is very difficult for us to imagine sitting in one place.
Thank you, sir. So the next question of today's session is, what is the role of public education and awareness in ensuring that citizens understand their rights and obligations under the new criminal law regime?
See, the role of public education remains the same which it existed under the old law. It's not like with the new law, the role of public education will change. Citizens needed to be apprised of their rights, obligations, duties, whatever, under the old law also, under the IPC also, and they need to know their rights under the BNS also. But that's a very separate question. That's a state objective or a state responsibility which has nothing to do with changing of laws. That remains. That's an obligation that always remains on the state. Now, a different point of discussion is whether the state government or whether any government thinks that it is worth investing in that. That's a separate question. That's not a question that a new criminal code can answer for you. But yes, I understand where that concern comes from, that now that we have new laws, and these are supposedly laws brought in by a new, independent, pro-democratic, pro-welfare government, constitutional laws as per our 1950 constitution. So now, yes, there is an added bonus, incentive, responsibility on the government to conduct these programs, to make its legal aid and legal education programs more robust, so as to reach out to common people who do not have an idea about the constitution, who do not know how laws play out in the court, and tell them what are the rights in case of arrest, what are the rights in case of detention. So yes, I agree with you that now with these new laws, there is an added incentive and an added responsibility.
Thank you, sir. So the third question of today's session is, what kind of drastic change will happen by changing the IPC and CRPC?
See, drastic changes, I have told you, I would just answer that in the first question, that while 70-80% of the things remain the same, it is the devil lies in the details of those 20%. So there will be convenience related issues. There will be issues of renumbering of provisions. There will be, like I said, issues of capacity building. So for lawyers who engage with the law at a lot of levels, it might not seem that big a task, because one provision remains the same. It's only the provision number which changes. But one has to understand that, like I said in my answer to the first question, that criminal law enforcement happens at a lot of levels. It happens from the level of a constable, havaldar, till the Supreme Court. So at every step, you have to ensure that the person who is entrusted with the task of implementing or interpreting the law has to be well versed with the new law, has to be well versed with whatever procedural changes, even though those might not be significant. They have to be trained in a very, very professional manner. So that training, that capacity building is the real challenge, in my opinion, for the government.
Thank you, sir. Sir, the fourth question is of the today's session is, does the new laws will clear the cases at speedy level?
No.
What is the most important and impactful thought pertaining why creating these new laws?
That I have already answered. I think I have already engaged a lot with such questions. See, the purported objective, the ostensible objective is decolonization. The ostensible objective is to usher in a new system to remove pendency of cases. But the harsh answer, the uncomfortable answer is no. And like I said, anybody who has engaged with the criminal justice system, things do not change overnight. The way our criminal justice system works, things do not and things will not change overnight. A lot of structural reforms are required at a lot of levels, and simply changing one code to the other is not going to have any real impact. Indian justice system, the criminal justice system, suffers from a lot of basic structural defects, basic structural lacunas, which have to be rectified. Right from appointment of judges to the way the trials happen, the way public prosecution, the manner in which prosecution happens by the PP, the manner in which defense defense attorneys defend a matter. A lot of things change, and these are things which, like I told you, see, these are things happening for hundreds of years. So there's a system in place. Actually, you can't bring in a new law and expect the system in place to simply get an overhaul overnight. So no, it's not going to change anything. It's not going to have any impact on speedy disposal.
Thank you, sir. So the fifth question of today's session is, what are some of the possible drawbacks of these laws according to you that would need to be properly addressed in near future?
I think I have already discussed it. See, the drawbacks, insofar as in terms of personal liberty concerns are concerned, I have laid it down. There are open-ended provisions which can be abused, which are open to misuse. Insofar as convenience is concerned, yes, a system has to be brought in place either by courts or by the legislature or executive, which makes the prevailing confusion easier for police agencies, for lawyers, for courts. Capacity building is a challenge. So these are certain drawbacks. These are, I would say, challenges. Drawbacks are, yes, these open-ended provisions, these ambiguous nature of certain provisions which make the law uncertain, like I was saying. It makes the law unpredictable. And that is the worst thing that can happen in criminal law, that your laws are unpredictable, that a citizen does not know whether these provisions can be used against him in cases of dissent or in cases of actions by the government. So yeah, these are drawbacks and these are challenges that need to be overcome. These are challenges that need to be understood and overcome by courts also, by reining in the provisions, by putting limitations by way of interpretation on the provisions.
So we'll be taking this last question. Sir, the question is, procedural laws can be applied retrospectively. But if we consider BNSS for which is CRPC for the matter, will it not lead to multiplicity of the petition and overburden to the courts?
See, that system is already in place. Now, suppose if there's a matter which was started before the 1st of July when the new laws came into place. So if an FIR was registered before the 1st of July, the substantive laws will continue to remain the same, which is the IPC by way of the savings provision. But the procedural laws will now be the new procedural laws, which is the BNSS. So that reconciliation exercise is already there, and that is exactly the challenge. See, because it is criminal laws, hundreds of permutations and combinations will arise. What will happen in one particular case may not happen in the other case because the facts will be different. In some cases, the FIR may have been registered. The complaint may have been initiated before the 1st of July, but the FIR was registered after the 1st of July. So how do we differentiate? These are questions that need reconciliation, and reconciliation is coming. It is coming from different high courts. It is coming from state governments. The thing is, these things need to happen fast, and these things need to happen at the basic level, because real criminal law enforcement happens in the cities and the towns and in the local police thana. So even if, say, tomorrow there are directives coming from the MHA or from one particular state government, whether it is reaching these towns and villages and the local thanas, that is important. Because in my head as a lawyer, I might be clear that this case, even though the substantive law will be IPC, by virtue of the new procedural law, BNSS will apply. But whether this clarity of thought or whether this legal clarity is there in the minds of those people right at the bottom who are implementing or who are in the authority, who are the authority for implementing, in position responsible for implementing these laws, whether it's clear to them or not is the real question. Because you and I as lawyers are not implementing the law. We are interpreting the law and just simply seeing whether the compliance is happening or not, or whether the action was in compliance or not. The real implementation of law, again, I'm emphasizing, is at the bottom down, is in the local thanas, in the cities and towns of India and villages. So that is the real challenge.
Thank you, sir, for answering these questions. We'll be wrapping up. In closing, we extend our heartfelt gratitude to you, sir, for accepting our invitation and delivering such an informative session. We trust that the audience found it both interesting and knowledgeable. Thank you once again, sir. And we eagerly anticipate the opportunity to host you in future again. Thank you, sir.
Thank you. Thank you, Kamlesh. Thank you, everyone.